Welcome back to the deep dive. Today we are opening a file that honestly feels less like a contract dispute and more like a battle of egos between two absolute titans of legal education.
Oh, definitely.
I mean, if you've ever lost sleep studying for the bar exam, you know the names involved here. We are dissecting Emanuel Law Outlines, Inc. v. Multi-State Legal Studies, Inc.
It is a fascinating clash. You have Emanuel, the premier study aid publisher, going head-to-head with the guys who run the bar review courses.
Yeah.
It's like the immovable object meeting the irresistible force.
Exactly. And on the surface, this looks like a simple missed deadline. Emanuel signed this massive long-term contract to provide study supplements to multi-state.
Right.
And Emanuel delivers one specific supplement about a month late, blaming a pretty serious illness, by the way, and the buyer, multi-state, just completely flips the table. They say, that's it, we are canceling the entire 3-year contract, deals off.
Which sets up one of the most classic and, expensive problems in commercial law.
Yeah.
When does a little hiccup in performance
Yeah.
justify blowing up the entire deal?
Right.
Because that's what multi-state did. They didn't just ask for a refund on the late book. They tried to walk away from a multi-year relationship.
It seems incredibly aggressive. I mean, we've all turned in work late. Usually you get a slap on the wrist, maybe a penalty. You don't get fired from a 3-year engagement.
Well, it certainly looks like they were looking for an excuse.
Mm-hmm.
You have to understand the context. Multi-state was locked into this deal, but the market was shifting. There's this strong implication that they just had buyer's remorse.
Ah, so they want it out.
They wanted out of the financial obligation, and when Emanuel slipped up on a deadline, multi-state saw what they thought was a golden opportunity to claim a total breach and just escape the contract entirely.
So they tried to weaponize a delay. But for that to work, the law actually has to be on their side.
Exactly. And to figure that out, the court had to untangle this really messy timeline. We have to look at, 3 things. Was the deadline actually moved? Did multi-state even fire them properly? And then the big one, was this breach actually bad enough to destroy the whole contract?
Let's start with that deadline. The written contract was crystal clear. Emanuel had to deliver the criminal procedure supplement by May 1st, 1993. That date comes and goes.
Right.
They didn't actually deliver it until June 3, 1993. That's a month late.
Which is, on its face, a breach. No question. If the contract says May 1st and you deliver June 3, you have broken the promise.
But here's the twist, and this is where it gets into he said, she said. Stephen Emanuel, the president of the company, had quadruple bypass heart surgery in February of that year.
Which is not a minor excuse.
Not at all. He claims that in early April, he got on the phone with Robert Feinberg, the head of Multi-State. Stephen says he explained he was behind schedule due to the surgery and this is key, he claims Feinberg agreed to move the deadline to early June.
A verbal extension. A handshake deal over the phone.
Exactly. But Feinberg denies it, flat out. He testified that in 17 years of business, he has never, ever agreed to an oral waiver. He says that conversation, at least the part about moving the date. It just never happened.
So now you have a classic he said, she said problem.
Yeah. So does an oral agreement like that even stand up in court?
Well, this gets us to the doctrine of oral modification. And the general rule is that while you can modify a contract verbally, courts are incredibly skeptical of it, especially when there's a detailed written contract already in place. They just hate these kinds of battles.
So how does a court decide who's telling the truth? Does it just come down to who they like better?
No, not at all. It came down to professional habits, to behavioral consistency. The court looked at the people involved. You have Lazar Emanuel, the general counsel, and Stephen Emanuel. The court noted they were experienced attorneys and, to use a witness' own word, sticklers.
Sticklers, I like that. So they were the type of guys who read the fine print.
And enforced it. There was evidence that in the past they had demanded payment immediately after a deadline. They papered everything. The court's reasoning was, if a significant change to a delivery date had actually been agreed upon, experienced lawyers like the Emanuels would have confirmed it.
They would have sent an email or a fax right away?
Immediately. Something like just confirming our conversation. The fact that there was no paper trail, that silence in the written record was deafening.
And so
the court's conclusion on this point was that no modification happened. The May 1 deadline was still in effect. Therefore, being late was technically a breach.
Okay, so Emanuel is in the wrong. They missed the deadline. So Multi-State says, great, you breached, we're canceling. And Multi-State claims they sent 2 letters, one on April 27 and one on May 7, notifying Emanuel of the breach and terminating the deal.
Right. They tried to fire them.
But Emanuel says, we never saw those letters. And this brings up a really technical point about notice of breach. I always thought if you mail a letter, that's it. That counts as notice. Isn't that the mailbox rule?
In many areas of law, yes. And under the UCC's default rules, notice is generally pretty flexible. You just have to take reasonable steps. But, and this is a huge but, this case hinges on contractual primacy.
Meaning that the contract itself trumps the default rule.
Exactly. The UCC lets parties write their own rules. And this specific contract was brutal. It explicitly required that the breaching party must receive written notice and then be given 30 days to cure the problem.
Receive being the key word, not sent, but received.
Precisely. And this is where multi-state really messed up. They sent these crucial termination letters by ordinary mail.
Just a stamp and a prayer.
Pretty much. They didn't use certified mail, no courier, no return receipt. This was despite Feinberg knowing full well that the Emanuels were sticklers who would hold them to the letter of the law.
So because they couldn't prove the letter actually landed on Emanuel's desk, the notice just didn't count.
That was the court's holding. The court found Emanuel did not receive the letters, and the result of that is huge. Because Emanuel didn't get valid notice of termination before they delivered the goods on June 3rd, they effectively cured the breach before a valid termination could even happen.
Wow, that feels like a technicality on steroids. They fixed the problem before they were officially told they were fired just because the firing letter was in the regular mail.
Welcome to contract law. The details matter. But let's just say for a second the notice had been received. We still have to answer the biggest question of the case. Was this one late book bad enough to cancel the whole 3-year deal?
Right. This is the concept of substantial impairment, and I struggle with this one sometimes. If a contract is broken, it's broken. Why does it have to be substantially broken to cancel?
Because in the real world of commerce, nothing is ever perfect. If every minor delay allowed you to just tear up a multi-year contract, business would grind to a halt. The law needs to distinguish between a technical breach like being a little late and a breach that truly guts the value of the entire contract.
Can you give us a visceral way to visualize that, something we can really latch onto?
Sure. Let's call it the rotting fish versus the dented can scenario. Imagine you run a high-end seafood restaurant and you sign a 12-month contract for fresh fish delivery every Friday.
Okay, I'm the chef.
Scenario A is substantial impairment. It's the first month. The fish arrives, but it is rotting and poisonous. This isn't just a bad delivery. It casts serious doubt on the supplier's entire ability to handle food safely. The trust is gone. You can likely cancel the whole year because the defect in this one installment infects your confidence in every single future delivery.
Right. I can't trust them next week or next month. The relationship is dead.
Exactly. Now, consider scenario B. No substantial impairment. First month again. The delivery van arrives 4 hours late because the driver got a flat tire. But the fish is still perfectly packed in ice. It's cold. It's fresh.
So I have my fish, but the schedule was messed up. It's annoying, but the product is fine.
Correct. It is a breach of the timeline. But does it ruin the value of the fish you're expecting in December? No. It doesn't mean the supplier is incompetent. You can ask for a discount, maybe, but you can't cancel the whole year. That is the standard the court applied here.
Okay, that clarifies it perfectly. We are looking for the rotting fish. So let's analyze Emanuel v. Multistate using that exact lens. First, what are the legally dispositive facts regarding this installment breach?
The facts are pretty simple. Emanuel law outlines was obligated to deliver a criminal procedure supplement by May 1. They delivered it on June 3. That's the breach. Multistate argued this 1-month delay ruined the value of the whole contract because students needed it for the bar and the lecturer, Feinberg, supposedly needed it to prepare his lecture.
And based on that, they canceled the whole thing.
They repudiated the entire 3-year deal.
And what was the core legal issue that came out of that cancellation?
The issue is whether a 1-month delay in delivering one supplement constituted a substantial impairment of the entire 3-year installment contract under UCC Section 2612.
So we need the rule. What rule of law did the court apply? Can you state the full black-letter rule and then break it down into its testable elements for us?
Absolutely. The court applied UCC Section 2612.3. The rule states that a default with respect to one or more installments generally does not excuse the non-breaching party's future performance. To allow cancellation of the whole contract, the breach must substantially impair the value of the whole contract. The court then broke this down into 4 specific elements to test that impairment.
Okay, what were they?
Element 1, impact on the ultimate consumer. Did it harm the students? Element 2, impact on the buyer's business reputation. Element 3, usefulness for internal preparation did the lecturer actually need it, and element 4, the buyer's own reaction and conduct regarding the breach.
Thank you. Now let's get into the court's elemental analysis. This is where the rubber meets the road. Let's walk through this step by step. How did the court apply the first element, impact on the ultimate consumer?
So the sub-issue here was simple. Did the students get the material in time for it to be useful? Multi-State claimed the students were left high and dry. But the court just looked at the calendar. The students received the supplement in early June. The bar exam wasn't until late July.
That's nearly 2 months.
Exactly. The court said that is ample study time. Plus, they had received 8 other outlines on time. So the conclusion was that the value to the students was preserved. This wasn't rotting fish. It was just a slightly later delivery of a perfectly good can.
Understood. Now, what about the second element, impact on business reputation? Multi-State argued that in the DAR prep world, reputation is everything.
They did. The sub-rule is whether the delay caused any tangible harm to Multi-State's brand. Feinberg claimed word of mouth is king, and that students complained. But when the court asked for proof, Feinberg came up empty.
Nothing.
0 documentation. No letters of complaint, no refund requests from angry students, nothing. And if people are really angry, they usually write it down.
Good point.
Furthermore, the court noted that Multi-State stopped offering the course later for totally unrelated reasons, so you couldn't even argue there was future enrollment damage. The conclusion was clear. No proven reputational harm. It was all just speculation.
That brings us to the third element, usefulness for internal preparation. This was the argument about the lecture meeting the outline. This part felt a little personal.
It was. The question was this material truly essential for Feinberg's lecture prep? Feinberg claimed he absolutely couldn't prep his criminal procedure lecture without Emanuel's outline in his hands by May 1st.
Which sounds plausible until you remember who Feinberg is.
Right. The court found this incredulous. I mean, this guy was a 17-year veteran lecturer. He had his own outlines he'd been using for almost 2 decades. The court basically said it did not believe an expert of his caliber needed an outside outline to prep a lecture.
It's almost a backhanded compliment.
It really was. You're too good to actually need this.
Yeah.
So the conclusion was the delay did not hinder his lecture preparation in any meaningful way.
The court essentially called his bluff by complimenting his expertise. I love that. Okay, and finally, the fourth element, the buyer's own conduct. How did Multi-State act when the books finally showed up?
This is so often the smoking gun in these cases. The sub-rule asks, did the buyer act as if the breach was critical? If you get rotting fish, you throw it out immediately.
You don't just let it sit there.
No. If you receive a critical urgent shipment late, you demand it instantly. But here, when Emanuel finally shipped the goods in June, Multi-State did not demand overnight shipping. They allowed UPS ground delivery.
Which takes, what, a week?
Depending on the distance, yeah. It's certainly not emergency speed. The conclusion from that is pretty simple. If the delay were truly substantial and urgent, Multi-State would have demanded the fastest possible shipping. Their lack of urgency proved the breach was minor. They acted like it was a dented can, not a crisis.
So after analyzing all 4 elements, the students were fine, reputation was fine, the lecturer was fine, and the shipping was slow. What was the court's final conclusion?
The court held there was no substantial impairment. The defect was trivial. Therefore, Multi-State had no legal right to cancel the contract. And here is the picker. By sending that fax in August repudiating the agreement, Multi-State was actually the one in total breach.
Wow.
They wrongfully terminated the contract.
That is a massive backfire. They tried to get out of the deal and ended up being on the hook for breaking it. What was the financial damage?
Emanuel Law Outlines was awarded $60,000. That represents the full contract price for years 2 and 3 of the deal.
Wait, the full price? Usually in contract law, if a buyer backs out, the seller has to mitigate damages, right? You have to try to sell the goods to someone else.
Usually, yes. But that brings us to a neat little rule, UCC Section 2709. If the goods are custom made and can't be resold, the seller gets the full price.
And these were custom.
Exactly. These outlines were branded and formatted specifically for Multi-State. They had a Multi-State's logo on them. They had no resale value to anyone else. Barbary wasn't going to buy them. So because they were custom goods, Emanuel gets the full payout.
Wow. So Multi-State ends up paying for books they didn't want, for years of a contract they tried to cancel, all because they overplayed their hand on a 1-month delay.
It's a cautionary tale about leverage. They thought they had it, but they misread the UCC.
This has been a fantastic breakdown. To make sure our listeners can actually use this, if you're a law student or a business owner looking at a late delivery, How do you diagnose this situation? Give us the checklist.
Absolutely. Here is your installment breach diagnostic checklist. 5 steps.
Mm,
Number 1, classify the contract. Is it a single delivery or an installment contract? If it's installments, separate deliveries over time, remember the bar for cancellation is much, much higher.
okay, step 1.
Number 2, check for waiver. Was the deadline modified? Be a cynic. Oral modifications are incredibly hard to prove. If it's not in writing, assume the original deadline stands.
Got it.
Number 3, check for notice. Read the fine print of the contract. Did it require specific receipt of notice? If so, the UCC default rules don't apply. And don't use regular mail to fire someone.
Don't do it.
Number 4, the substantial impairment test. This is the big one. If one installment is bad, do not assume the whole contract is dead. Ask, is the defect curable? And does it ruin the entire future value of the deal? Is it the rotting fish? And look at how the non-breaching party acted. Did they show urgency?
And finally,
Number 5, remedy calculation. If the buyer wrongly repudiates, check if the goods are custom. If they are custom made, the seller is probably getting the full check.
that really crystallizes it. It seems like the big takeaway is to take a very deep breath before you call your lawyer to cancel a deal.
That is the ultimate lesson here. In commercial contracts, not every delay is a disaster. The law demands you distinguish between a hiccup and a heart attack. Multi-state treated a hiccup like a heart attack, and it cost them 60 grand.
A hiccup versus a heart attack. I love that. We're going to leave it there. Thanks for diving deep with us, and we'll catch you on the next one.